Okay, it is Tuesday, November the 19th, and welcome to week 3 of Introduction to Criminal Law. And I'm Professor Richard Wright, and you should be aware of the fact that um, when we reach week 3, this is the midway point after this. And as I said before, I'll say it again. All assignments from week 1 through 3 that are not submitted by the end of week 4, will not be accepted unless I've made previous arrangements with you. And so be aware of that fact. And then also be aware of the fact that this week is actually basically midterm for this course, so you'll have an exam. So I'm going to go right into sharing my screen. Okay. So you see this information. I'm not going to go over that again. So you see that discussion post rubric, and then that the rubric for each written assignment is in the assignment itself. And rubrics are very important. I said that from day one. And then you'll see we're at week 3, and lectures take place every Tuesday, 8:30 p.m. to roughly 9:30 p.m. Central Standard Time. And you see below here are the week 1 open house, week 2, and then after tonight you'll see week 3. I do want to bring to your attention that the week 2 assignment that were due Sunday, due to the problem with Blackboard that took place on Sunday, all written assignments were extended to yesterday by 11:59 p.m. Central Standard Time. So if you got them in after that, then you're still going to be late. But if you got them in Monday, I will not deduct points. Now that doesn't apply to discussion posts, but it applies to your written assignments and only those written assignments. So now let's go down and let's take a look at our week 3 announcement. So this week, last week we had crimes against property. So this week we're going to talk about crimes against persons. And I sent to you the PowerPoints for chapters 4, 5, and 6 of the textbook. And we're going to go over the topics: homicide, battery, domestic violence, sexual assault. And then I'm going to just, again, remind you about the key terms for practice relating to special circumstances, homicide, and then a practice quiz. So we're going to talk about that. Very important this week. Be sure to participate in the discussion assignment. What type of homicide is this? The initial post is due tonight at 11:59 p.m. Central Standard. And the reply post is due Saturday night at 11:59 p.m. Central Standard Time. Finally, your written assignment, spousal rape, and then you have the quiz, which is time, which, as I said before, and I'll say it again, it is equivalent to your midterm, and it will cover the topics weeks 1, weeks 2, and of course today's lecture, week 3. So the best way to prepare for that is to go back and look at the PowerPoints for each of those weeks and be able to get ready for the exam. I do recommend taking the exam on Sunday, because then you'll have a chance to go through all the materials. So now let's take a look at the course calendar, which I do every week. And here it is. And it tells you where we are here. This is right here where we are. Today is the 19th. And it tells you that you have your initial post that's due tonight, your reply post due the 23rd, which is Saturday, and then your written assignment and quiz and key phrase is due by 11:59 p.m. Central Standard Time on the 24th. Okay, and then we will meet back here again next week. But keep in mind that we got one more lecture next week for this month, and then we got just 2 lectures in December. So let's go over to December so you'll see. One on the 2nd and one on the 9th. This is the week after Thanksgiving. Okay, and then this is the last one because the course ends December 13th. No exceptions. December 13th. And you're going to have then your time quiz. That's your written assignment for that day. Like as I said, that's going to cover weeks 4, 5, and 6. Then your reply post, and not due Sunday, but Saturday, but the 13th. And then it tells you here that this course officially ends at 11:59 p.m. on Friday, December the 13th. All right. So now let's go take a look at the actual module and see what we have here in terms of assignments. And here we are. The discussion posts, you are well aware of what goes in here, and you deal with that. What kind of homicide is this? And then your written assignment is a 2-part assignment. Part 1, you're going to examine and determine the types of crime that are committed. Now, when it says a short paper addressing the questions about the scenario, and a short paper in this case means a minimum of 2 pages, not counting the cover page, not counting the reference page. APA citations as well, okay? So you're going to deal with this scenario, and you're going to answer these questions. Make sure that you use APA citations and references. Do not rely solely on your textbook. As a matter of fact, rely little on your textbook. I want you to conduct research. And then part 2, you'll conduct an interview, provide interview questions to determine which criminal law has been violated, and here's the scenario. All right, so this is going to be a minimum of 1 page. Remember, your papers should always be double space. Double space is what you really need for all of your written assignments. And then you're going to deal with these 2 questions. Again, if you need help with your assignment, there is the guide that I've been talking about since the beginning of this course that you can go to, and it will help you with your written assignment, the online library for research, APA toolkit, tutoring, and writing lab. Now, let's go back and look at the rubric. So you click on the assignment, and then it'll tell you the due date, and then it tells you click on this to see the rubric. And the rubric is very important because it tells you what you have to do. And it says it has to be 2 pages long. Remember, double space, not single space. And then a minimum of 1 page for you conducting the interview. So it's going to be 2 pages for the written portion, 1 page for the interview. And don't run the 2 together. And then these are the details. They should be in paragraph form. No spelling errors. And then this is the APA requirements that you are required to satisfy. Okay? Very important that you follow the rubric. And then one of the things that you have to do is you have a timed quiz set for 30 minutes. And students have asked me how many questions. I will not answer that for you, but you'll have 1 opportunity to complete this exam. And during this exam, you'll be alerted as to when your time is about to run out. You'll be alerted when 5 minutes, when 1 minute, and when 30 seconds. And once the time expires, the exam will automatically be submitted. Again, I recommend that this quiz be taken Sunday after you've had a chance to go over the materials from week 1, week 2, and week 3, because this test is going to cover those areas. All right. Then your live lecture, which I'm going to give the keyword at the end of this session. So now let's go into talking about the content of the topics that we're dealing with: crimes against people. And so this is the reading assignment, which I shared earlier, which you got the PowerPoints for. So we're going to talk about the topic of homicide, battery, domestic violence, and sexual assault crimes. And then we're going to just briefly show you how the key terms operate, how the practice for special circumstances, practice for homicide, and then your practice quiz. Because as you see, you have a real quiz, which is equivalent to your midterm in this course. All right. So now let's talk about homicide. Now, what is homicide? As a general rule, basically, it's simply killing a person and taking the life of an individual. And it can either be justified, or what we call lawful, or it can be unlawful or unjustified, which depends upon the circumstance situation. Police officers are under the requirement that they not use deadly force or excessive force unless it is necessary to protect themselves or someone else. So whether or not the law enforcement officer goes excessively will determine whether or not they're guilty of murder or homicide, like manslaughter. In our jurisdiction, we have at least one police officer who was guilty of excessive force in the Jason Van Dyke case involving a young man by the name of Laquan McDonald, who the police officer fired 16 shots into the individual, and it made national and international news. And so that person was found guilty of second-degree murder by a jury, as well as aggravated battery with a firearm, and so that resulted in aggravated assault with a firearm, rather, and that resulted in the death of this young man. So when the police officers have deadly force to prevent bodily harm or death to others, it's considered as lawful, and those are the only circumstances: prevent great bodily harm or death to themselves or to others. When a person who is not a law enforcement officer intentionally kills a person, because, like, for example, the example they give about a person believed they cheated on him, then that is sometimes referred to as murder or manslaughter, depending on all the total circumstances. So murder is the unlawful killing of one person, so it's determined to be unlawful. So now we're going to briefly look at this. Now, first-degree murder is generally what we call in our jurisdiction murder, and one is guilty of that when the killer has premeditation and what we call malice and a forethought, or they've planned the activity with the intent to kill that individual. And the intent is determined by the actions of the killer at the time the person is killed, or statements that might say a premeditation before an act is carried out, such as, I'm going to kill John Doe, and then the person kills John Doe. In that case, it was premeditated because the statement itself of I'm going to kill John Doe created the premeditation aspects of it, and then the actions carried out after that would result in murder in the first degree. So the following elements where a death is caused, remember homicide, there's always a death, okay? There cannot be a homicide unless there is a death of a human. It has to be a human being. And it's either going to be with intent to kill that person or premeditation, that they planned it out, okay? So they talk about here as in first-degree murder cases, intent has to be demonstrated. For example, it was later determined that the killer had told another person of his intent to kill a victim and carries out the act. Then in that case, the previous statement would be used against that person to satisfy the element of premeditation. And other times, intent is for obvious reason, where a person might scream out to a person, "I'm going to kill you," and then shoot them. Or, "You're going to die," and then fires the gun at that person. So the death, it was clearly the act of an intentional as opposed to an accidental discharge of a firearm. Therefore, it's not manslaughter. We'll talk about that in a few minutes. Sometimes intent reaches the stage where we deal with motive. Evidence of motives could also show that the killer intended to kill. So if a person, for example, it says here, submits email evidence, or there's email evidence indicating that the killer planned and intended to kill the victim to collect insurance money or for whatever reasons, this would be an element for first-degree murder. The key thing that you got to remember is very simply the premeditation and the intent that comes out of the actions. And premeditation can be demonstrated by an action before that, such as writing something, or either actually then saying something and then taking an act that results in the death of that individual. Now, second-degree murder is often referred to as manslaughter. And the reason it's a lesser included offense. And what it means is basically in a situation here is some of the elements is that the defendant, and this says in the state of Colorado, knowingly caused the death of a person. Now, the element of second-degree murder is different from the first because it doesn't have to be premeditation or the mindset of the person at the time of the act, but it includes the intentional killing of one by another, not accidental, intentional. So second-degree murder in many jurisdictions is also known as voluntary manslaughter, okay? When the killing is done without any prior intent but occurs in the heat of passion, such as a person walking in on their wife in the bed with another man, and then they kill them both immediately at that particular time. So the question is, if an ordinary person in those circumstances would lose control and then kill the person, that's in what we call the heat of passion. So look out for that heat of passion issue, because it is generally one of the issues that they like to test you on when they give you these exams, I'm just saying. And these killings are when they happen at the moment, not later. So it is important. So it says here, it would be difficult to lessen the severity of murder if Bob came home to find his wife in bed, but then hunted Jim down the next day and killed him. Then we're not talking about, so it has to be simultaneous. It has to be something that the individual is doing that results in their not having control at that moment. You kind of begin to get the picture of it. So in Tennessee, the example is pretty clear. Voluntary manslaughter is the intention of knowingly killing another in a passion. Notice you hear passion constantly involved here. And a normal person would respond in that method. So that's second-degree murder, or either what we call voluntary manslaughter. All right. So now the special circumstances. You're going to run across this too, but you're going to have some little tests to help you prepare for that. Now, special circumstances is really kind of, how should I say, a gray area, and applied in death penalty and homicide cases most of the time. So let's talk about first-degree homicide special circumstances. Some factors that aggravate it are often considered in death penalty cases. For example, two aggravating factors is that the future dangerousness, or the probability that the defendant would commit another criminal act, and the action was wanton, vile, horrible, inhumane, or torturous, or demonstrates a depravity of the mind. If neither of these aggravating factors are present, according to the state of Virginia, first-degree homicide cases, defendant is sentenced into life and in prison, not death. So these are special circumstances which, again, pay a little attention to, but not a whole lot. Now, regarding second-degree homicide special circumstances, two circumstances that make up the element of knowing in second-degree murder is adequate provocation. So we've already kind of talked about that already. And then coercion out of necessity. So such as the death was because the person was forced to do it. For example, let's say if the example here where it talks about Jack, who was taken hostage, who was taken hostage, and the hostage taker had a gun to his head. And the hostage taker, under those circumstances, tells Jack to shoot Bob. Well, under those circumstances, the rest, Jack will shoot Bob. And then it's what we call second-degree homicide under special circumstances because of the coercion, because he was going to get his head blown off if he didn't shoot Bob. Okay? And so we're not going to go into all of these details. So now let's jump to, let's close the special circumstances up, and let's talk about involuntary manslaughter. Now, this is pretty much what it means, involuntary. When you hear something that's involuntary, you should be able to watch out for the fact that it's probably like doing something that could be with reckless disregard, but not intentional. So like driving under the influence or something along those lines, driving under the influence of drugs or alcohol. But there is no premeditation or malice or evil intent. But the actions, as I said, the reckless actions such as driving under the influence, maybe speeding excessively, cause the death. This is known as involuntary manslaughter. So the actions themselves are reckless and result in the death, but it wasn't that you were aiming to shoot or kill that person. Maybe a gun went off accidentally, then that necessarily may not be involuntary manslaughter. But if you're driving a car and you kill someone, then you could find yourself guilty of involuntary manslaughter. So what it involves is utter disregard or utter indifference, which makes it different from first degree, or it's a reckless act. So utter disregard for human life, as it says here, is defined as a course of action which shows a deliberate intention to harm, or which, if not intentional, shows just indifference to the person and disregard of the person's safety, such as speeding in a situation there. In contrast, reckless simply means to be indifferent or careless to the welfare of other people. So both of these are instances where death has been caused absent intent, no intent. And so to prove the utter disregard is challenging because it has to be shown that the actions equated to conscious disregard. In other words, just ignored that the possibility of death can take place by the actions that the individual takes. And then degrees of involuntary manslaughter. And this gives an example. This is a perfect example here, and I'm going to read it out and comment about it. It says, it's 11:30 p.m. on a clear but cold January day, and the streets are dry, and a 23-year-old named Jim, who is intoxicated, pay attention, is operating his vehicle on a residential road with a 25-mile-per-hour speed limit. So his girlfriend, who is also drunk, decides to egg him on, and Jim decides to impress Jane, and he picks up speed up to 80 miles per hour. He drives through a stop sign and collides with another vehicle occupied by a middle-aged couple who are killed instantly. So did Jim demonstrate an utter disregard for human life, or were his actions merely reckless? I think that you'll find that his actions demonstrate utter disregard for human life. That's the key right there. All right. So it was the speed that he was already intoxicated, but the speed that he picked up demonstrated, I don't care about the life or who it might hurt. I'm just going to speed it because I want to impress Jane. Okay, and so that's where it comes to that point. Then there's this thing called one-punch homicide. Well, this comes about where, for example, if a person punches a person and they actually die as a result of the punch. The one-punch homicide has been used to describe when people, when a person intentionally batters that person that punches another, but the one punch results in the death. So you can learn more about that by looking at this. You're not going to run into this on the exam, I can tell you that. All right. And then these are some references where you can find details on it. So that's it for homicide. So now let's talk about the act of battery. Again, this is another criminal act on the individual, human being, and it is a actual misdemeanor in most instances, and it is battery, if it's what we call simple battery, that is maybe striking someone or not something that's, that can cause permanent injury or death. When you strike a person and cause a minor injury. But substantial battery is a felony, and aggravated assault usually involves a weapon of high propensity for serious injury. So the common elements of battery include an intentional act to injure another without their consent, okay? And in some jurisdictions, it's referred to as assault. But for purposes of us, I want to explain something to you as we go down and we look at this little chart here. First of all, let me show you something here. If I hold up my hand and you see me to strike somebody and I'm close to them, then I put them in the state of assault, where I create a belief that I'm going to do harm to them. All right, that's it. But then when I hit them, make contact, then I commit the battery, and it involves a physical contact. Now, I'm not talking about rubbing up against somebody accidentally. I'm talking about a situation where it was intended to do so. So, touching a person without their permission, against their will, and involves battery. So usually we use the term assault and battery. And I explain to people that assault always precedes battery. And so it is very, very confusing to use the term assault to also mean battery. So assault in the common law preceded a battery, and that's how you have to remember, okay? So if I don't hit you, then it's assault. If I fire a gun at you and it misses you, it could be assault. If I strike you, it could probably be attempted murder. But my point being is that, let's say I swing at you and I miss you. Well, that could be assault. But if I make contact with you, then it's elevated from assault to battery. And usually you hear them referred to together. So, as I said here, most states determine the term assault and battery are used. Moving forward, though, as we talk about here, battery is the term to describe when one person intentionally consents, and I don't like the term assaults another and cause injury. I mean that they just actually did something to them. I hate using that word assault in there because it confuses people. So in order to prove battery, before we move on, is that it has to be intentional, okay, not accidental. So the seriousness of the battery will be determined by the injury, the extent of the injury that the individual has, okay? Now, intentionally causing bodily harm to another is simple battery. Bodily harm is defined as physical pain or injury, illness, or any impairment of physical condition. That's what bodily harm is. Intentionally causing great bodily harm or serious bodily harm is another more serious battery offense and is a felony. So the great bodily harm or serious bodily harm comes when a person may be unconscious or they have extreme pain or some kind of disfigurement, such as throwing acid or hot water or something on those individuals, dismembering a person, cutting off a member of their body, an organ or something along those lines. So if a victim suffers a broken jaw, or laceration requires stitches, dislocation of a finger, then the felony charge of battery, such as the substantial, would be the appropriate charge. So you see, you get to the seriousness of it. And then you be aware that the difference between a misdemeanor and a felony, as I've shared before, is that with a misdemeanor, the sentence potentially could be up to a year and or a fine. In a felony, it is a year and more in terms of incarceration. And generally, misdemeanors land a person in jail. Generally, felonies end you up in prison, okay, because you're going to be gone for more than a year. Now, sometimes people are in jail awaiting trial, but that's not what we're talking about. So now let's talk about what we call mayhem. Mayhem. Yeah, you talk about mayhem. And there's a commercial out that I think is State Farm, and they talk about protecting yourself from mayhem. Well, mayhem is serious bodily harm, and California lays it out. It says every person who unlawfully and maliciously deprives a person of a member of their body or disables or disfigures that individual, puts out an eye or does something like that, is guilty of mayhem. And it's consistently defined across the country the same way. So let's look at this scenario here, and we'll conclude with this part with this, where Angela, who's 18, was at a party with a 21-year-old male. Drake and both, his name was Drake, both were intoxicated. As the night went on, Angela and Drake did a bizarre ritual in a horror cult-like situation where Angela consent and participated with Drake to slit her wrist and drink her blood. Now then, to clearly show their commitment to each other, Angela allowed Drake to chop off her pinky finger with a meat cleaver. Absent her right pinky, Angela eventually became lightheaded and was dropped off at a local hospital where she told the emergency room what happened. In turn, the doctors notified police. So did Drake commit mayhem? Under the statute here, the answer would probably be yes. And because it's consistent across the country. It involved in being deprived of a member of the body, disfigurement, or one of those types of things. Now, so battery occurs between complete strangers and among those who love each other, and so we're going to talk about that later, okay, when we look at domestic violence in just a few minutes. All right. Right now, let's go to domestic violence. Now, domestic violence is something that I'm all too familiar with because of my life. I already shared that with you during week 1, that I lost both of my parents over domestic violence situations. I also told you about how the guy who was my mother's boyfriend continuously would beat her and assault her in my presence. As you can see, that kid sitting at the top of the stairs, we were like that. We didn't have stairs, but we were subjected to seeing the abuse of my mom at the hands of this person. And then my dad's death resulted out of a domestic situation because my dad was confronting this guy, Webster Scott, and was confronting him about a potential relationship with my mom. Now, I didn't know that then, but I learned it years and years later. And the man took out the knife and stabbed him. And then my mom, of course, covered for him. And then she ended up 5 years later becoming his next victim of murder. So domestic violence is a crime that attaches itself to such as a battery from a domestic relationship. There has to be a domestic relationship, and it's called domestic violence because it takes place as a result of the domestic relationship. And there are penalties above regular criminal cases because of the situation that occurs. The safety of people, male and female now, are in danger, and children as well. So there's not just one accepted definition of what we call domestic violence. Look at what the National Coalition Against Domestic Violence defines domestic violence as the willful intimidation, look at this, intimidation, physical assault, remember, physical assault, battery, sexual assault, and other abusive behavior as part of the pattern of power. That is the key to domestic violence. It is an act of power and control where one partner perpetrates over another. And in domestic violence, if you take the course, you will discover this thing called cycle of abuse. And what that really means is that individual who commits domestic violence on a person will take that person and will hurt that person, and then they will make up with that person, and that person will let them back in their life, and then next time it happens, and it may be worse. And so it keeps going on, and it goes round and round until ultimately it could end up in the death. My mother was warned by many family members during the period 57 to 63, that this man was going to go too far in hurting her. He broke her arms, he stabbed her with knives, he hit her with bats, and that ultimately he was going to go too far. And that's what he did Memorial Day of 1963, when he actually killed her. And that's what happens all too often. And dealing with domestic relationships, it is involving, as it says here, in many states, such as battery between two adults, at least 18 years or over, who live together. That is, they have lived together or been intimate, or have lived together, or have a child in common. They don't have to live together. And then in that case, it elevates itself to domestic violence, okay? So then the offense of battery becomes more serious in that kind of scenario, because it's a domestic relationship. Now, as I said before, and I'll say it again, domestic violence, as it says here, can take many forms, including physical violence, sexual assault, emotional and economic harm. Basically threatening an individual who's a partner in those kind of things. Again, it's a thing of power to maintain control over that individual. And like I said, it occurs within the context of a domestic relationship, as I previously have described it to you. It also involves incest. It involves, as I said already, sexual abuse, and it can involve where a person actually just takes an individual and just beats them. And so it says it's more specific from a criminal law perspective. When you investigate domestic violence incidents, and I learned this from being a police officer, law enforcement officers must determine if the act occurred within the context of the domestic relationship. And there are procedures now in place in many jurisdictions where people can go to court and they can get what we call temporary restraining orders, or as it's generally called now, orders of protection. When I was coming up, it was called a peace bond, and what that meant was that the individuals had to stay away from those people. I remember one of the last things that happened with the Scott after he had gotten out of prison was I had a chance to see him, and he was pulled into court because he was looking for us, not to hurt us, but the judge issued an order and naming myself, naming my spouse, and other members, my siblings, and other family members, children, that this person could never come around them, and that that was the last time I saw him. So it was a form of what we call a peace bond at that time, which is now known as an order of protection. And people, you can go to domestic relations court and obtain these now, where the prosecution will, with the state's attorney, will represent the individuals who are victims. So from a domestic violence perspective, two adults, at least 18, who live or have lived together or have a child in common, okay? And that's pretty much the definition all across the board. And so law enforcement officers should enforce these, and there are now rules that allow them to take individuals out of a place by force, if necessary, okay? And this last paragraph here says, enforcement of criminal laws allow police officers to use discretion and determine the best way to resolve a situation. And so the key thing is to get that person removed from the location, all right? So the key thing is to take and protect the individuals from further abuse from that individual. All right. Now, that's pretty much what I want to cover about domestic violence. There's a whole lot of other stuff here, and you can take time to look at that. I will say this, that as a defense attorney, I would never, and never did, represent a defendant in a domestic violence case for obvious reasons, because I was very much a victim, and as my parents were taken away. And then I also later found out that after he did this, and we were living with an aunt and an uncle, my uncle sexually assaulted my siblings. And so that is another form of domestic violence. He was never charged, arrested, or prosecuted because my aunt, as many people found in those sexual abuse or assault cases, did not believe the child and would side with the male person. Tragic, but that happened. All right. Okay. Now, here's one right here that you should really focus in on. And I was talking to someone about this kind of a situation, but it wasn't sexual. But listen to this. It says sexual assault within the context of domestic relationship is prohibited in all of the states. But prior to 1978, before I became a lawyer, it was believed that rape within the context of marital relationship was not legally possible because it wasn't prohibited by law. But in 1979, when a case happened in Massachusetts, this person was convicted of forcing his estranged wife. Now, here's the key. If they're estranged, they're not together, okay? Maybe it's order of protection, or they're separated, or either they're not living together, and have forced her to have sexual intercourse after breaking into her place. And they were in the process of divorce, but they were still legally married. So he was convicted of sexual assault, which is domestic violence, and sentenced to 3 to 5 years in prison. So other states, like Massachusetts, in the Chapter 209A, Abuse Prevention Section 1 definition specifically prohibits a person within a domestic relationship from sexually assaulting the other person in a relationship, and states that it is abuse causing another to engage involuntarily in sexual relations by force, threat, or duress. So that's something that you look at in terms of dealing with sexual assault as well. So here we go with the sexual assault. And I think that one of the things that you should be aware is in sexual assault cases, again, they happen more often than not, but it used to be that rape itself was called sexual assault. Well, it is called sexual assault in the statutes, but it's still considered as rape. And so it is. It doesn't require that actual physical intercourse take place, but an unlawful touching, however slight, of a person's private genital areas, or doing something where you invade their private areas. And these are sex crimes, are very sensitive, and during investigations, there's a whole lot of things that take place, such as having swabs. Now we have the DNA issue, dealing with checking the sexual areas of individuals who claim that they were sexually assaulted. And there's a whole lot of things that take place. And so the thing with dealing with this is that law enforcement has to investigate quickly to secure the evidence, such as the DNA, and to get that, because it will diminish in a real quick period of time. Sexual assault statutes categorize people, for example, by first, second, third, or fourth degree. And so sexual assault is a very serious offense. And in some jurisdictions, like Minnesota, they're categorized as first through fifth degrees. And I'm not going to go through all of these. But the key thing is dealing with sexual penetration of a person. And then if you have a minor, then you get into the issue of statutory rape, where a person who's a minor can't give consent. I remember one time I was sitting in a courtroom and waiting on my case, and a person was charged with statutory rape, and the defendant was alleging that the person, he didn't know that that person was that young. Well, statutory rape is what we call a strict liability crime, which means that it's not determined on whether or not you have knowledge of it. The only elements that are necessary is to prove there was sex that took place and that the person was underage. And that's it. That is all that is required. And you can be found guilty of that. So I'm not going to go through all these different degrees. You can take time to go through that. But I do want to talk about concluding with dealing with what I said a few minutes ago, statutory rape, where if a person is a juvenile, and it varies depending on the jurisdiction that it happens in. But the key thing is to protect minors. And it says here in bold print, it says our strict liability laws. And then these laws, as I said, don't require a showing of intent, and the mere engagement of engaging in sexual intercourse or contact with a person who cannot legally consent because of their age in and of itself is unlawful. And it's not a defense to say that the minor consented, or because you couldn't tell the minor, or they produced some phony ID and things of that nature. So it is basically to protect the minor, okay? And so that's what I wanted to conclude in terms of this. I want to, before I give you a key phrase, show you again these key terms. You can go through and you click on this, and it opens up, and then you go with the flashcards, and then you open this up and allow it to be seen. Here we go, right here. And then here's some scenarios. Okay, doesn't require that intercourse take place, but also includes unlawful touching, however slight, of any part of the victim's genital area with any object of another person without their consent. And here's the answer. We just did it. Sexual assault. So then you go to the next one. When one person kills another, but there is no premeditation or malice, evil intent, but reckless actions cause the death. And you flip on that. Involuntary manslaughter. And you can go through each of these, and you can deal with that, okay? And I do recommend going through them all, okay? So now, let's go down to the next one, and that's practice for special circumstances. And we already kind of talked about special circumstances just a little bit. So you can start the activity. Jane and Phil have been married for 10 years. They have 2 children together. Jane also has a drinking problem. Jane came home drunk and argued with Phil. Phil threatened to leave Jane and take the children if she didn't get help. Enraged, Jane shot Phil and fled the house with their children. Which of these special circumstances would likely be claimed here? Which one do you think? A, B, C, or D? C. So you think vileness? How about this? Adequately provocation. Adequate provocation would likely be claimed because she was so upset for his actions to taking the children. All right? Does that make sense now? Okay. Let's go do one more. Mary and John have been married for 15 years. Mary discovers that John has been having an affair for the past year. They both argue and sleep in separate beds that night. In the middle of the night, still very upset, Mary stabs John once with a knife while he's sleeping. You know, it's funny, I actually had a similar type of case that someone I know actually was found guilty of a crime. John survives, and Mary tells the police she couldn't control herself. Which circumstance would likely be claimed, would she be claiming? A, adequate provocation. Okay. I don't think you can get too far with it, but that's right. It is adequate provocation, because adequate provocation would likely be, in this case, because she was upset. Just remember the key thing. I tried to fake you out there, but you didn't go for it. Adequate provocation would likely be claimed because Mary was so upset that about the affair that she stabbed him in the heat of passion. Now, one of the problems that might, one of the problems that might be here, that could be argued, is that they argue in separate beds, in the middle of the night, she's still upset, and she stabs him once with a knife. That would be her probable argument, but I think a good prosecutor would say, no, she planned it. She laid in the bed and planned it. It didn't happen simultaneously. So that's the out of it, though. But because of special circumstances cases, that's where you sometimes bring a little extra into it. Okay, and so that's how those things work. So you go over those and do all of them. All right, and then the last part, scrolling right down to the bottom. Okay, well, we do a homicide before the quiz. So homicide classifications, and you go through each of these. Start the activity. And Frank has a long-standing hatred for Kim. Frank purchased a handgun and hid behind the bushes outside Kim's apartment. When Kim exited, Frank shot her and killed her. What homicide classification best describes this case? Which one? I didn't see it. Yep, I think you got one. You're right, because it was he planned it. So you're right. You're absolutely right. Okay. So now let's go to, okay. Oh, I didn't choose it. So yeah, submit it. Yep. And then continue. Okay, one last one. Jackson and two of his friends are hanging out on the top floor of a parking ramp. Jackson has a violent history, targets another man, Rick, and tells his friends, watch this, I'm going to kill that guy. Jackson punches Rick in the face, picks him up and throws Rick over the ledge. Rick falls to his death. What classification best applies to this case? A, B, or C? Okay. Remember, Jackson and his two friends are hanging out, and he says, I'm going to kill this guy, and then he kills him. That's the answer right there. Because, remember, he said he was going to do it, and then he did it. Remember, that establishes intent based on the actions. His words kind of nailed him there. Okay? So that's how these things work. So now, the last and final part is the quiz. Make sure whatever you do this practice quiz. You will regret it if you don't. And I'm not going to explain to you why. You should be able to figure that one out. So the intent to cause death with premeditation is considered what type of murder? A, B, C, or D? Yep, premeditation. There it is. It jumps out to you like a neon sign. Last one. A father comes home to find his daughter's 17-year-old boyfriend, of whom he doesn't even like, about to have consensual intercourse with his 17-year-old daughter. Outraged, the father kills the boyfriend. The father is likely to claim what? A, B, C, or D? You said B. You said B, coercion. It's between these two. This is one, because he loses control. Adequate provocation would be argued in light of the circumstances because he had lost self-control. So those are things you got to watch out for. And that's it for this one. And so I'm going to give you a key phrase or a word. Murder. That's it. So give me that, and you'll get your points. So I'm going to say good night. Hope to see you guys next week at the same time, when, again, we'll be in week 4, which will be the second half of the course. And again, I remind you that, yeah, you can take the practice quiz as many times as you want to, but not the quiz, not the actual quiz. But yes, you can. You can take all of those little things, those little scenarios, more than once to help you. That's a good studying tool, but keep in mind that the test is not going to be just about Chapter 3. It's going to be Chapters 1 and 2 as well. So you might be mindful to go back and check the practice quizzes as well in those. That would probably be a good strategy to use in addition to using the PowerPoints as well. Okay? Anything else? Okay. Well, I'm going to say good night. You're welcome, and I'll see you next week. Good night. Yeah, I got a little more work to do before I go to bed, but I will be going to bed within the next hour for sure. You know, that's 9:35 my time, about 10:30 latest, and then because I get up early and I do a lot of stuff, and then in the eve tomorrow I got another lecture, and then Thursday. So, all right. Good night. See you next week.